The absence of any competing legislative power. The King, each House of Parliament, the constituencies, and the law courts either have at one time claimed or might appear to claim independent legislative power. It will be found, however, on examination that the claim can in none of these cases be made good. The King. Legislative authority originally resided in the King in council, and even after the commencement of parliamentary legislation there existed side by side with it a system of royal legislation under the form of ordinances, and, at a later period, of proclamations. These had much the force of law, and in the year 1539 the Act 31 Henry VIII c. 8 formally empowered the Crown to legislate by means of proclamations. This statute is so short and so noteworthy that it may well be quoted in extenso. Quote, "The King, for the time being, with the advice of his council, or the more part of them, may set forth proclamations under such penalties and pains as to him and them shall seem necessary, which shall be observed as though they were made by Act of Parliament. But this shall not be prejudicial to any person's inheritance, offices, liberties, goods, chattels, or life, and whosoever shall willingly offend any article contained in the said proclamations shall pay such forfeitures, or be so long imprisoned, as shall be expressed in the said proclamations, and if any offending will depart the realm, to the intent he will not answer his said offence, he shall be adjudged a traitor." End quote. This enactment marks the highest point of legal authority ever reached by the Crown, and probably, because of its inconsistency with the whole tenor of English law, was repealed in the reign of Edward VI. It was curious to notice how revolutionary would have been the results of the statute had it remained in force. It must have been followed by two consequences. An English king would have become nearly as despotic as a French monarch. The statute would further have established a distinction between laws, properly so called as being made by the legislature, and ordinances having the force of law, though not in strictness laws as being rather decrees of the executive power than acts of the legislature. This distinction exists in one form or another in most continental states, and is not without great practical utility. In foreign countries, the legislature generally confines itself to laying down general principles of legislation, and leaves them with great advantage to the public to be supplemented by decrees or regulations which are the work of the executive. The cumbersomeness and prolixity of English statute law is due in no small measure to futile endeavours of Parliament to work out the details of large legislative changes. This evil has become so apparent that in modern times Acts of Parliament constantly contain provisions empowering the Privy Council, the judges, or some other body to make rules under the Act for the determination of details which cannot be settled by Parliament. But this is only an awkward mitigation of an acknowledged evil, and the substance no less than the form of the law would, it is probable, be a good deal improved if the executive government of England could, like that of France, by means of decrees, ordinances, or proclamations having the force of law, work out the detailed application of the general principles embodied in the acts of the legislature. In this, as in some other instances, restrictions wisely placed by our forefathers on the growth of royal power are at the present day the cause of unnecessary restraints on the action of the executive government. For the repeal of 31 Henry VIII c. 8 rendered governmental legislation, with all its defects and merits, impossible, and left to proclamations only such weight as they might possess at common law. The exact extent of this authority was indeed for some time doubtful. In 1610, however, a solemn opinion or protest of the judges established the modern doctrine that royal proclamations have in no sense the force of law. They serve to call the attention of the public to the law, but they cannot of themselves impose upon any man any legal obligation or duty not imposed by common law or by Act of Parliament. In 1766, Lord Chatham attempted to prohibit by force of proclamation the exportation of wheat, and the Act of Indemnity, 7 George III c. 7, passed in consequence of this attempt, may be considered the final legislative disposal of any claim on the part of the Crown to make law by force of proclamation. The main instances where, in modern times, proclamations or orders in council are of any effect are cases either where, at common law, a proclamation is the regular mode not of legislation, but of announcing the executive will of the King, as when Parliament is summoned by proclamation, or else where orders in council have authority given to them by Act of Parliament. Resolutions of either House of Parliament. The House of Commons, at any rate, has from time to time appeared to claim for resolutions of the House something like legal authority. That this pretension cannot be supported is certain, but there exists some difficulty in defining with precision the exact effect which the courts concede to a resolution of either House. 2 points are, however, well established. First, the resolution of neither House is a law. This is the substantial result of the case of Stockdale and Hansard. The gist of the decision in that case is that a libellous document did not cease to be a libel because it was published by the order of the House of Commons, or because the House subsequently resolved that the power of publishing the report which contained it was an essential incident to the constitutional functions of Parliament. Secondly, each House of Parliament has complete control over its own proceedings, and also has the right to protect itself by by committing for contempt any person who commits any injury against or offers any affront to the House, and no court of law will inquire into the mode in which either House exercises the powers which it by law possesses. The practical difficulty lies in the reconciliation of the first with the second of these propositions, and is best met by following out the analogy suggested by Mr. Justice Stephen between a resolution of the House of Commons and the decision of a court from which there is no appeal. Quote, I do not say that the resolution of the House is the judgment of a court not subject to our revision, but it has much in common with such a judgment. The House of Commons is not a court of justice, but the effect of its privilege to regulate its own internal concerns practically invests it with a judicial character when it has to apply to particular cases the provisions of Acts of Parliament. We must presume that it discharges this function properly, and with due regard to the laws, in the making of which it has so great a share. If its determination is not in accordance with law, this resembles the case of an error by a judge whose decision is not subject to appeal. There is nothing startling in the recognition of the fact that such an error is possible. If, for instance, a jury in a criminal case give a perverse verdict, the law has provided no remedy. The maxim that there is no wrong without a remedy does not mean, as it is sometimes supposed, that there is a legal remedy for every moral or political wrong. If this were its meaning, it would be manifestly untrue. There is no legal remedy for the breach of a solemn promise not under seal and made without consideration, nor for many kinds of verbal slander, though each may involve utter ruin, nor for oppressive legislation, though it may reduce men practically to slavery, nor for the worst damage to person and property inflicted by the most unjust and cruel war. The maxim means only that legal wrong and legal remedy are correlative terms, and it would be more intelligibly and correctly stated if it were reversed so as to stand, where there is no legal remedy, there is no legal wrong. End quote. The law therefore stands thus. Either House of Parliament has the fullest power over its own proceedings, and can, like a court, commit for contempt any person who, in the judgment of the House, is guilty of insult or affront to the House. The case of the Sheriff of Middlesex carries this right to the very farthest point. The sheriff was imprisoned for contempt under a warrant issued by the Speaker. Everyone knew that the alleged contempt was nothing else than obedience by the sheriff to the judgment of the Court of Queen's Bench in the case of Stockdale and Hansard, and that the sheriff was imprisoned by the House because under such judgment he took the goods of the defendant Hansard in execution. Yet, when the sheriff was brought by habeas corpus before the Queen's Bench, the judges held that they could not inquire what were the contempts for which the sheriff was committed by the House. The courts, in other words, do not claim any right to protect their own officials from being imprisoned by the House of Commons for alleged contempt of the House, even though the so-called contempt is nothing else than an act of obedience to the courts. A declaration or resolution of either House, on the other hand, is not in any sense a law. Suppose that X were by order of the House of Commons to assault A out of the House, irrespective of any act done in the House, and not under a warrant committing A for contempt, or suppose that X were to commit some offence by which he incurred a fine under some Act of Parliament, and that such fine were recoverable by A as a common informer. No resolution of the House of Commons ordering or approving of X's act could be pleaded by X as a legal defence to proceedings, either civil or criminal, against him. If proof of this were wanted, it would be afforded by the Act 3 and 4 Victoria C9. The object of this Act, passed in consequence of the controversy connected with the case of Stockdale and Hansard, is to give summary protection to persons employed in the publication of parliamentary papers, which are, it should be noted, papers published by the order of one or other of the Houses of Parliament. The necessity for such an Act is the clearest proof that an order of the House is not of itself a legal defence for the publication of matters which would otherwise be libellous. The House of Commons, quote, by invoking the authority of the whole legislature to give validity to the plea they had vainly set up in the action of Stockdale and Hansard, and by not appealing against the judgment of the Court of Queen's Bench, had, in effect, admitted the correctness of that judgment and affirmed the great principle on which it was founded, viz. That no single branch of the legislature can, by an assertion of its alleged privileges, alter, suspend, or supersede any known law of the land, or bar the resort of any Englishman to any remedy, or his exercise and enjoyment of any right, by that law established. End quote. The vote of the parliamentary electors. Expressions are constantly used in the course of political discussions which imply that the body of persons entitled to choose members of Parliament possess under the English Constitution some kind of legislative authority. Such language is, as we shall see, not without a real meaning. It points to the important consideration that the wishes of the constituencies influence the action of Parliament, but any expressions which attribute to parliamentary electors a legal part in the process of lawmaking are quite inconsistent with the view taken by the law of the position of an elector. The sole legal right of electors under the English Constitution is to elect members of Parliament. Electors have no legal means of initiating or sanctioning or of repealing the legislation of Parliament. No court will consider for a moment the argument that a law is invalid as being opposed to the opinion of the electorate. Their opinion can be legally expressed through Parliament, and through Parliament alone. This is not a necessary incident of representative government. In Switzerland, no change can be introduced in the constitution which has not been submitted for approval or disapproval to all male citizens who have attained their majority, and even an ordinary law which does not involve a change in the constitution may, after it has been passed by the Federal Assembly, be submitted on the demand of a certain number of citizens to a popular vote, and is annulled if a vote is not obtained in its favour. The law courts. A large proportion of English law is in reality made by the judges, and whoever wishes to understand the nature and the extent of judicial legislation in England should read Pollock's admirable essay on the science of case law. The topic is too wide a one to be considered at any length in these lectures. All that we need note is that the adhesion by our judges to precedent, that is, their habit of deciding one case in accordance with the principle or supposed principle which governed a former case, leads inevitably to the gradual formation by the courts of fixed rules for decision, which are in effect laws. This judicial legislation might appear at first sight inconsistent with the supremacy of Parliament, but this is not so. English judges do not claim or exercise any power to repeal a statute, whilst Acts of Parliament may override and constantly do override the law of the judges. Judicial legislation is, in short, subordinate legislation carried on with the assent and subject to the supervision of Parliament. Alleged legal limitations on the legislative sovereignty of Parliament. All that can be urged as to the speculative difficulties of placing any limits whatever on sovereignty has been admirably stated by Austin and by Professor Holland. With these difficulties we have at this moment no concern, nor is it necessary to examine whether it be or be not true that there must necessarily be found in every state some person or combination of persons which, according to the Constitution, whatever be its form, can legally change every law, and therefore constitutes the legally supreme power in the state. Our whole business is now to carry a step further the proof that, under the English Constitution, Parliament does constitute such a supreme legislative authority or sovereign power as, according to Austin and other jurists, must exist in every civilized state, and for that purpose to examine into the validity of the various suggestions which have from time to time been made as to the possible limitations on parliamentary authority, and to show that none of them are countenanced by English law. The suggested limitations are three in number. First, Acts of Parliament, it has been asserted, are invalid if they are opposed to the principles of morality or to the doctrines of international law. Parliament, it is in effect asserted, cannot make a law opposed to the dictates of private or public morality. Thus Blackstone lays down in so many words that the, quote, law of nature being coeval with mankind and dictated by God himself is of course superior in obligation to any other. It is binding over all the globe, in all countries and at all times. No human laws are of any validity if contrary to this, and such of them as are valid derive all their force and all their authority, mediately or immediately, from this original. End quote. And expressions are sometimes used by modern judges which imply that the courts might refuse to enforce statutes going beyond the proper limits, internationally speaking, of parliamentary authority. But to words such as those of Blackstone and to the obiter dicta of the bench, we must give a very qualified interpretation. There is no legal basis for the theory that judges, as exponents of morality, may overrule Acts of Parliament. Language which might seem to imply this amounts in reality to nothing more than the assertion that the judges, when attempting to ascertain what is the meaning to be affixed to an Act of Parliament, will presume that Parliament did not intend to violate the ordinary rules of morality or the principles of international law, and will therefore, whenever possible, give such an interpretation to a statutory enactment as may be consistent with the doctrines both of private and of international morality. A modern judge would never listen to a barrister who argued that an Act of Parliament was invalid because it was immoral, or because it went beyond the limits of parliamentary authority. The plain truth is that our tribunals uniformly act on the principle that a law alleged to be a bad law is ex hypothesi a law, and therefore entitled to obedience by the courts. Secondly, doctrines have at times been maintained which went very near to denying the right of Parliament to touch the prerogative. In the time of the Stuarts, the doctrine was maintained not only by the king but by lawyers and statesmen who, like Bacon, favoured the increase of royal authority, that the Crown possessed under the name of the prerogative a reserve, so to speak, of wide and indefinite rights and powers, and that this prerogative or residue of sovereign power was superior to the ordinary law of the land. This doctrine, combined with the deduction from it that the Crown could suspend the operation of statutes, or at any rate grant dispensation from obedience to them, certainly suggested the notion that the high powers of the prerogative were to a certain extent beyond the reach of parliamentary enactment. We need not, however, now enter into the political controversies of another age. All that need be noticed is that through certain powers, as for example the right of making treaties, are now left by law in the hands of the Crown, and are exercised in fact by the executive government, no modern lawyer would maintain that these powers or any other branch of royal authority could not be regulated or abolished by Act of Parliament, or, what is the same thing, that the judges might legally treat as invalid a statute, say, regulating the mode in which treaties are to be made, or making the assent, it says, or the Houses of Parliament, I think it's of the Houses of Parliament, necessary to the validity of a treaty. Thirdly, language has occasionally been used in Acts of Parliament which implies that one Parliament can make laws which cannot be touched by any subsequent Parliament, and that therefore the legislative authority of an existing Parliament may be limited by the enactments of its predecessors.